A father who was convicted in the hot car death of his son is fighting to get a new trial. On the hot, humid morning of June 18, 2014, Justin Ross Harris strapped his 22-month-old son, Cooper, into the rear-facing car seat in his SUV before heading to work.
And I know how much he loved Cooper. I mean, he loved Cooper with his whole heart. I mean, there wasn't nothing he wouldn't do for that child. He
cherished him.
Yeah, he did.
Surveillance video captured Harris holding Cooper and ordering breakfast at a Chick-fil-A near their home. After leaving the restaurant, Harris said he intended to drop off Cooper at a daycare in the Home Depot headquarters in Metro Atlanta, where he worked as a web designer. But after he left work, Harris says he made a devastating discovery. Little Cooper was still in his car seat. The toddler had been trapped in the hot car for more than 6 hours, with temperatures in the vehicle reaching above 100 degrees. An autopsy later confirmed Cooper died of hyperthermia. Harris was arrested later that night. And after a 3-month investigation, Harris was indicted by a grand jury and charged with 8 counts, including malice murder, felony murder, and cruelty to children in the first degree. Prosecutors added more charges after they found that Harris had been sending sexually explicit text messages to at least 6 women, including a teenager.
They tried to make it look like he was sexting on his phone knowing his child was in the car.
And that's not true.
He was sexting on the phone, there's no doubt about that. But they never did prove that he knew the child was in the car.
Investigators say in the days before Cooper's death, Harris made online searches related to babies in hot cars, statements that would later prove untrue. Nevertheless, the damage was done in the court of public opinion. Harris's attorneys asked for a change of venue because of extensive pretrial publicity. Harris's mother, Evelyn, told CourtTV the media attention was unbearable.
And everything was so publicized before the trial that there was no way he could have gotten a fair trial. No way, because the press had him pronounced guilty before his trial.
The judge agreed and moved the trial 300 miles southeast of Metro Atlanta to the coastal city of Brunswick in Glenn County, Georgia. During the trial, prosecutors portrayed Harris as a man who had been living a double life. They said he intended to kill his son Cooper because he wanted to live a child-free life. The jury heard testimony from several women who Harris had been sexting on that fateful day. But the defense said Harris was a loving father who experienced a memory lapse, who simply forgot to drop his son at daycare. Harris's then wife, Leanna, said he was forgetful and absent-minded when she testified for the defense.
Was he the kind of person that was very focused, or was he easily distracted?
I would say he's easily distracted. I guess a good example would be, maybe getting a paycheck and forgetting to cash it.
After about 5 weeks of testimony, the jury convicted Harris of murdering his son Cooper. The judge praised the jury for its verdict when she sentenced Harris to life in prison without the possibility of parole.
They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child.
Now, 4 years after he was sentenced, Harris wants a new trial. His defense attorneys say the court denied Harris a fair trial when it failed to sever unrelated charges tied to his sexual infidelities and sexting an underage girl. The defense says the court forced Harris to defend himself against a charge of intentional murder of a child after drowning the jury in morally reprehensible bad character evidence.
And that bad character evidence were all things that he was doing while his son was dying. I mean, that was part of it, things he did before, and was part of the motive, according to prosecutors. All right, today, day one of this huge hearing. Chanley Painter, CourtTV legal correspondent, on the ground in Cobb County, Georgia, and joins us tonight. Chanley, great to see you. Give us the big picture, kind of set the stage, because we know in 2020, every trial, every hearing's being done a little differently. Where was everyone, and how did Ross Harris look today?
Great question. So this is different. This is a Zoom hearing. Now the judge is on the bench inside the courtroom, inside the courthouse behind me here in Cobb County. She's sitting on the bench as if court is in session as a normal day. But when I'm in there watching, the parties aren't present, so the attorneys are zooming in virtually. The defendant is zooming in from prison where he's being held here in Georgia. He seemed pretty stoic. He's sitting there at the table. He has a notepad and pen. He's paying attention, and we haven't heard from him at all. His attorney is doing most of the talking and questioning, calling witnesses today. So we had 2 witnesses so far in this motion for a retrial hearing, one from a memory expert and then one of the former attorneys of Ross Harris, who represented him back during the trial in 2016, again appearing virtually over Zoom. The prosecutors, even though their office is in the courthouse behind me, they are zooming in as well. It's all part of this COVID-19 era that we are in, and really you can see it affecting the entire area here, Benny. The courthouse, it's not the buzz or as busy. I know it's close to the holiday and there's not much court anyways, but you can definitely tell a difference. They've even kind of shut off some of the entrances. You can only enter in one door of the courthouse, and not a lot of action here, but it's been really interesting to see and listen in person in the courtroom and virtually how this is all happening. And other than a couple of little technical issues setting things up in the morning, it's gone pretty smoothly.
You know, I'm looking at Ross Harris right now, and he looks much different, right? I mean, at the trial, he looked like someone that was kind of shocked, right? Now he looks like someone who is, I wouldn't say angry, but I guess he's obviously older, right? He's a few years older, but he just looks kind of like he's got a chip on his shoulder. And my guess is because he believes he's been wrongfully convicted. But only he knows the truth. I mean, he's really the only one that knows 1,000% exactly what was inside his mind that day. But there was an expert, a memory expert, who took center stage today, Dr. David Diamond, a memory expert, and he talked about Ross Harris and his normal routines that he would take. Let's take a listen to a little bit of that testimony.
Now, are there any, you reviewed our case, and you've talked in detail about how you did it and things like that. In Ross Harris's case, did you find any facts or factors or circumstances that would be consistent with the change in routine that you just talked about?
Yes, I had. From my interview with Ross Harris, as well as other information that I gathered, I saw that he had a routine. His routine was, and it's pretty much every day, that he would get up with Cooper, have breakfast with Cooper. He would then prepare him for the day. He would then leave home, take Cooper to daycare. He would often then go to the Chick-fil-A. He went to Chick-fil-A probably 4 or 5 days a week. Typically go through the drive-through, pick up his breakfast, and then go to work. That was his typical routine.
Did you come up with other routines that sometimes he did, other variances of that?
So there were other routines. Rarely Cooper wasn't with him. So he also had the routine in which he would drive straight from home. He would stop at Chick-fil-A for breakfast, typically going through the drive-through, and then go straight to work. It was relatively rare that he didn't go to Chick-fil-A, but the other typical routine was that he would drive from home, take Cooper to daycare, and if he wasn't going to Chick-fil-A, he would then drive straight to work. Those 3 are really his primary routines that had gone on for months to years.
All right, so put this all in perspective for us, Chanley. Number one, why is he testifying now? Did he testify at the trial? And what's the purpose of having him tell us all this stuff now, or tell the judge this stuff now?
Because he didn't testify in the original trial, the defense is lodging a couple of different grounds, if you will, why Dr. Diamond is so essential, why there were errors in the first trial that would garner a new trial at this stage. And first is ineffective assistance of counsel. So the new attorney for Ross Harris is alleging that the defense counsel back during the trial, by not calling this doctor, this renowned expert on memory, that was ineffective assistance of counsel. It would have made a difference in the outcome of the case. So now they're proffering his testimony today to show the judge what he would have testified to if he had been given the chance to during the trial. He's going through his research. A big issue, though, and this is another ground for the defense, is that they complain that the trial court, the judge, at the time of the trial, actually before the trial, erred in allowing the state to compel Dr. Diamond's notes. The defense calls these work product or confidential notes that he had during interviews with Ross Harris that violated privilege, that gave the state an unfair advantage at trial. And that was the reason they didn't call him initially at the trial. In fact, let's listen to Maddox Kilgore, the second witness today, explain.
This, confidential work product, which was notes between the lawyer and the expert, were going to have to be turned over. And we were concerned for lots of reasons. I very specifically warned Dr. Diamond that this was going to create a real problem with credibility. If they had his notes, that the state could then come in and demand that he give an answer for every issue, every statement that was on that piece of paper, answer the question the way that Ross Harris had answered it. And of course, that would have put Dr. Diamond in an incredibly difficult position.
Now, in the state's response to the defense motion for a new trial, Vinny, which is 80 pages long, mind you, they say that these notes of Dr. Diamond, they weren't work product, they weren't confidential, they were just summaries of his interviews and his meetings with Ross Harris, and that they had every right to have those handed over to the prosecution because these were the notes that the expert formed the basis of his opinion at the hearing or at the trial back then. So their counter is no, it was proper. The ruling by the judge should still stand.
Okay, so ineffective assistance of counsel, though, that's going to be a stretch because his attorney, Max Kilgore, one of the best in the state of Georgia. I mean, he's really, he's a great lawyer. So that's going to be a tough argument in front of this judge. And then you got to convince the judge that she made a mistake. There was something else that came up that Kilgore testified about, and that was where Ross Harris parked his car. Let's take a listen.
The parking lot was a very large parking lot, and he could have very easily put that car in very more isolated places in the parking lot where nobody would have walked by the car. Not only that, there were very, very few trees in the middle of that parking lot. And we noticed that where he parked was not only in the middle of the lot, but it was under the shade of a tree, which of course is contrary to the suggestion that somehow he was intentionally parking in a way to bake his child in the car.
All right, Chandler, that's a great argument. It makes common sense, but what does it have to do with a new trial? Why not just, did he argue that to the jury in the original case and they rejected it? What's going on?
Right. Well, a big part of this defense motion for retrial is to pick apart the right of the prosecution to prove a motive. They keep saying they wanted to introduce all of this evidence that he was doing that day while parking the car on the way to work that maybe threw him off or was a distraction to why he would leave his 22-month-old son in the car. And here to counteract that he intended this, because again, the defense is that this was an accident, that they have an affirmative defense. The state has to rebut an affirmative defense beyond a reasonable doubt here in the state of Georgia. And for them, you know, when you don't have the intent of, oh, well, let's park in the middle of the parking lot where there's no shade, this car will get hot faster than normal. That wasn't here. And so that's the point the defense is trying to bring up, is that the court erred in the rulings by allowing the prosecution to introduce a lot of evidence that was prejudicial and showed bad character on Ross Harris that really, to the defense, had nothing to do with his memory failing him that morning.
Okay, they know the case better than I do, but I don't know if a shady tree is going to help them. You know, it's a great argument to a jury. Listen, it's a great argument to a jury, but I don't know how it gets to where they want to go.